Hello dear students, I welcome you all to today's lecture on winding up of companies. The objectives of this lecture are to understand the concept of winding up, to understand the various kinds of winding up, that is, winding up by the National Company Law Tribunal and voluntary winding up. The third objective is to understand who can apply for the winding up of a company. The definition of winding up is that it is a term commonly associated with the ending of a company's existence. In fact, winding up is a process by which the assets of the company are collected and realized, its liabilities are discharged, and the net surplus, if any, is distributed in accordance with the Articles of Association of the company. Professor L.C.B. Grover has defined winding up of a company as a process whereby its life is ended and its property administered for the benefit of its creditors and members. An administrator called a liquidator is appointed who takes control of the company, collects its assets, pays its debts and finally distributes the surplus, if any, among the members in accordance with their rights. Thus, in the words of Pennington, winding up or liquidation is the process by which the management of a company's affair is taken out of its directors' hands, its assets are realized by a liquidator and its debts and liabilities are discharged out of the proceeds of realization, and any surplus of assets remaining is returned to its members or shareholders. At the end of the winding up, the company will have no assets or liabilities and will therefore be simply a formal step for it to be dissolved, that is, its legal personalities as a corporation shall be brought to an end. It must, however, be pointed out that a company is not dissolved immediately at the commencement of winding up. Its corporate status and powers continue throughout the process of winding up. In fact, winding up precedes dissolution. When the winding up of a company commences, it is said to be in the process of liquidation, but it does not cease to exist until dissolved. The object of winding up of a company is to realize the assets and pay the debts of the company expeditiously in a fair manner in accordance with the law. Winding up of a company is different from the insolvency of an individual because the company can never be declared insolvent under the Insolvency Act, even though it is unable to pay its creditors. It can only be wound up. The Companies Act 1956 had prescribed three modes of winding up of a company, namely 1. By the courts, 2. Under the supervision of the courts, and lastly voluntary winding up, which may be members' voluntary winding up or creditors' voluntary winding up. However, the Companies Act of 2013 prescribes only two modes of winding up. The first is winding up by the National Company Law Tribunal and the second is voluntary winding up. The Companies Act of 2013 does not acknowledge the distinction between a member's voluntary winding up and a creditor's voluntary winding up. First and foremost, we shall discuss the winding up by the National Company Law Tribunal. Section 271 of the Companies Act 2013 provides for compulsory winding up. The compulsory winding up of a company is also known as winding up by the National Company Law Tribunal. It is initiated by an application by way of petition to the National Company Law Tribunal for a winding up order. The circumstances under which a company may be wound up by the tribunal in its discretion to order the winding up of a company are stated in Section 271 of the Companies Act 2013. They are as follows. The first is inability to pay debts. This is provided for in Section 271, Clause A. A company may be ordered to be wound up if it is unable to pay its debts. A company is deemed to be unable to pay its debts if a creditor makes a demand for an amount exceeding rupees 1 lakh and does not get his money within 21 days, that is 3 weeks, after it fell due. And the creditor is then entitled to make a petition to the National Company Law Tribunal for an order of winding up of the company. The debt must, however, be really due and not under dispute. Where a financially sound company disputed the claim on a bona fide grounds, that was held not to be a neglect to pay, and the tribunal refused to make an order for winding up of the company. The tribunal does not allow this remedy to be used as a shortcut or a cheap device to coerce payment of a disputed debt. The power is discretionary. The Supreme Court pointed out in Madhusudan Gordhan Das and Company versus Madhu Moolan Industries Private Limited that in the exercise of its discretion, the tribunal can take into account all relevant factors, including the wishes of the creditors, the benefit that will accrue to the petitioners, and the nature of the debt. Secondly, a company is unable to pay its debts if execution or any other process issued on a decree against the company is returned unsatisfied, in whole or in part. Lastly, a company is unable to pay its debt if the tribunal is satisfied that the company is commercially insolvent. In Krishna Sethi Basav Rao versus Gubashi Machine Tools Private Limited, the Andhra Pradesh High Court held that an order of winding up, besides being discretionary, has to be resorted as a last measure when it is in the interest of not only the company but also the public. In the instant case, the court declined to exercise such discretion in favour of the petitioners who had come up before the court with an ulterior motive and not with a bona fide motive. They were seeking the winding up of a unit. In Jagdamba Polymers Limited versus Neosac Limited, the Tribunal of Madhya Pradesh observed that there is a rule of caution not to entertain petitions of winding up unless a very strong prima facie case is made out on facts, else it affects the very existence of a company in the commercial market. It will be too disastrous for any running company to suffer an order of winding up for non-payment of a debt, and that too when it has certain bona fide reasons not to pay the debt. If there is a reasonable prospect of resurrection and revival of a company and its effective and commercially successful functioning, the tribunal may not pass an order of winding up. However, there may be circumstances where winding up may be more effective way of settlement for the creditors and even the shareholders to recover whatever could be salvaged from the assets of the company. That would really be so in the case of companies whose continuance would not be commercially viable and may result in incurring further commitments by way of avoidable overheads. In such a case, there would be no purpose in trying to keep alive the company and allow it to continue its uneconomic functioning. That will only result in creating further liabilities against the company, unnecessarily causing corresponding reduction in the distributive assets. It must, however, be noted that the tribunal is not expected to direct the continuance of the functioning of the company in each and every case. The matter has to be decided applying the following tests. Number 1, whether continuance of the functioning of the company would be in the best interests of the creditors primarily. Number 2, whether revival and resurrection of the company would be possible, especially taking into consideration the circumstances such as the degree of insolvency, the likelihood of confidence of customers in view of its last performance, etc. Third, whether continued functioning would not result in reducing the reliable assets but would enable the company to function normally and economically. Fourthly, if there is a scheme before the tribunal and whether it could be implemented and the feasibility of its success. Fifth, If resurrection is proposed, the initial outlay and recurring expenditure on that account and the availability of resources for the same, and whether such recommencement of business of the company is likely to further reduce the distributable assets of the company. In Dr. Prish Machines and Powders Private Limited versus Octahedron Super Abrasives Private Limited, the petitioner filed a suit against the respondent for his failure to pay the debt under Section 394 of the Companies Act 1956, which corresponds to Section 271 of the 2013 Act. But the High Court of Delhi dismissed the petition as no case was made out against the respondent company. The evidence on record showed that the respondent had issued post-dated checks in favor of the petitioner which were never encashed by the petitioner, and no explanation was given as to why these checks were not presented. Petitioner's reluctance and failure to encash the checks of the respondent company. Moreover, the alleged debt was not a debt and the respondent company had disputed the claim of the petitioner company. Therefore, there was no merit in the case, and the High Court rightly declined to entertain the petition for winding up under Section 433 Clause E of the Companies Act 1956, corresponding to Section 271 Clause 1 Subclause A of the Companies Act 2013. From the above analysis, it may be summed up that the inability to pay debts on the part of the company is a usual ground for filing the petition of winding up of the company. However, every debt cannot be a ground for winding up of the company. A company may be wound up on the ground of being unable to pay its debts only when the following conditions exist. A. The amount of debt exceeds Rs 1 lakh. B. The sum must be definite, presently payable, and there should be no bona fide dispute about the debt. C. The creditor makes a written demand of payment. D. The demand is signed by the creditor or his agent or legal advisor duly authorized in this behalf. E. The demand has been served by causing it to be delivered at the registered office by registered post or otherwise. F. The company must have neglected to pay the demanded sum or to secure or compound the same to the satisfaction of the creditor for 3 weeks. The next ground for winding up of a company is special resolution. Section 271 Clause B. A company may be wound up by an order of the tribunal if a special resolution for its winding up has been passed by the company itself. The tribunal, however, is not bound to order winding up simply because the company has so resolved. The power of the tribunal being discretionary, it may not be exercised if the winding up is opposite to public interest or it is against the interests of the company. It must be pointed out that winding up by a special resolution is not a common occurrence because of the fact that companies generally have a very large number of shareholders, and if they want the company to be wound up, they would prefer its voluntary winding up, which is comparatively cheaper and less time consuming. It is quite often noticed that the companies which are in a very bad financial position and confronted with the problem of income tax or sales tax defaults, protracted litigation with creditors and prosecution by the registrar of companies, etc., prefer compulsory winding up by the tribunal by passing a special resolution so that all these problems are passed on to the official liquidator and the company's burden is considerably reduced. The third ground on which the company can be ordered to be wound up is when it has acted against national interest. This is provided in Section 271 Clause C. If it is found that the company has acted against the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, the company may be ordered to be wound up. The fourth ground is winding up of sick companies. This is provided again in Section 271, where more than 50% of secured creditors of a company apply to the National Company Law Tribunal for winding up of the company with relevant evidence for its failure to offer security or compound their debt, the tribunal may pass an order for winding up of the company under Chapter 19 of the Companies Act 2013, which relates to revival and rehabilitation of sick companies. The fifth ground is winding up on the application made by the registrar. If an application is made by the registrar of the companies or by any other person authorized by the central government by notification under the Act, the tribunal is of the opinion that the affairs of the company have been conducted in a fraudulent manner, or the company has been formed for a fraudulent or unlawful purpose, or persons concerned in the formation or management of its affairs have been guilty of fraud, misfeasance or misconduct in connection therewith, and that it is proper that the company may be wound up. The next ground for winding up is when there is a default by the company in filing its return with the registrar. Where the company has made a default in filing with the registrar its financial statements or annual returns for immediately preceding 5 consecutive years, the tribunal may order the winding up of the company. The next ground for winding up of a company is under the Just and Equitable Clause. Section 433, Clause F of the Companies Act 1956 provides that the company can order the winding up of a company when it is of the opinion that it is just and equitable that the company should be wound up. This corresponds to Section 271, Clause 1, Subclause G of the Companies Act 2013, which again provides that the tribunal can order the winding up of a company when the tribunal is of the opinion that it is just and equitable that the company should be wound up. It is the remedy of last resort. In this case, the tribunal has wide powers and has complete discretion to decide when it is just and equitable to order the winding up of the company. The discretionary authority of the tribunal even enables it to subject the exercise of the illegal rights to equitable considerations. The discretion of the tribunal under this clause is very wide, and the courts have exercised this discretion on a variety of grounds which may be generalized in the following categories. Firstly, when there is deadlock in the management of the company. The tribunal may order winding up on the just and equitable ground. This occurs when only the two members of a company are not on speaking terms. Mere dispute is not enough. For example, in Re Yenichi Tobacco Company Limited is an illustration in this point. In the instant case, two cigarette manufacturers, W and R, who were trading separately, agreed to amalgamate their business by forming a private limited company of which they were the only shareholders and directors. They had equal voting rights, and therefore their disputes were to be resolved by arbitration. But one of them dissented from the award of the arbitrator. They became so hostile that they were not even on speaking terms with each other. Thus, there was complete deadlock, and therefore the company was ordered to be wound up, although its business was flourishing. The High Court of Delhi in Brown Forman Mauricus Limited versus Jagjit Brown Forman Limited and others held that winding up of the company under Section 271, Clause 1, Subclause G of the Companies Act 2013 is not based on any statutory measures. Instead, it essentially depends on the equitable discretion of the tribunal, for which the tribunal generally takes into consideration the following facts. Number 1, the conduct of the petitioner. Number 2, the possible effect of winding up on the concerned company, its shareholders, members, creditors, employees, etc. Number 3, whether the petitioner himself is not responsible to create a situation for winding up of the company. Number 4, the tribunal is expected to invoke the provisions of Clause 2 of Section 273 of the Companies Act 2013 in rare cases and order winding up only when no better alternative is left for the parties. The second ground for winding up of the company is where the company has lost its substratum. The substratum of the company is deemed to have been lost where A. the subject matter of the company is gone. B. The main object for which the company was formed has failed to materialize. C. It is impossible to carry on the business of a company except at a loss. D. The existing and possible future assets insufficient to meet the liabilities of the company. When the main object of the company has failed to materialize or its substratum has failed, the company may be ordered to be wound up. This occurred when a company incorporated to work a German patent could not obtain it, or when a company's assets were seized by the creditor. Temporary acquisition or difficulty is not the same thing. The next ground for winding up of a company under the just and equitable clause is on the ground of mismanagement and losses. The National Company Law Tribunal is justified in ordering the winding up of the company under the just and equitable clause where it is not possible for the company to carry on a business except at losses and there is no prospect of achieving profits. However, mere apprehension of losses on the part of shareholders is no ground for winding up under this clause, where, due to the mismanagement in the company, its share capital is constantly decreasing and it is running into heavy losses, the tribunal may order the winding up. In Rajamundry Electric Supply Corporation Limited versus A. Nageshwar Rao, there was mismanagement in the company and most of the capital was used by the vice president of the company for his personal use. His group had attained majority due to the death of one of the directors of the company. The president and the shareholders could not do anything to improve the management of the company and put it on track. The company's financial position further deteriorated due to non-collection of bills of huge amount due from the government for supply of electricity. In view of these facts and circumstances, the court deemed it just and equitable to order the winding up of the company under Section 433, Clause 3 of the Companies Act 1956, which now corresponds to Section 273, Clause 1, Subclause D of the Companies Act 2013. The fourth ground where it is just and equitable to wind up the company is when the principal or majority shareholders have adopted an aggressive or oppressive or squeezing policy towards the minority shareholders. In the case of B.K. Prathapan, a person named Prathapan who was an NRI through his mother induced Ramanujam to start a company with an initial investment of 5 lakh rupees. Prathapan, who was the main shareholder of the company, later came to know that Ramanujan convened a meeting of the board of directors of the company on October 24, 1994 and passed a resolution that he may be allotted equity shares. Prathapan was not informed about this resolution. As a result, he lost his majority shareholding and became a minority shareholder vis-a-vis Ramanujam. Aggrieved by this, Prathapan filed a petition for winding up of the company under Section 433F corresponding to Section 272 of the Companies Act 2013, alleging that at the time of starting the company, Ramanujam had not invested any money and he was drawing huge salary as a managing director of the company without contributing to the promotion of the company's business. Ramanujam contested the winding up petition on the ground that Prathapan being an NRI, the petition filed by him was not maintainable. The Company Law Board, which has now been replaced by the National Company Law Tribunal, however, did not accept this plea of Ramanujam as Prathapan's name was registered as a shareholder in the shareholders register. Allowing the petitioner, the Company Law Board held that it was fit case of ordering the winding up of a company on the just and equitable ground. In Sangram Singh P. Gaikwad versus Shanti Devi Gaikwad, the Apex Court held that an act which is burdensome, troublesome and wrongful may be considered as an oppressive act. In the context of a company, an act of the majority which is detrimental to the interests of the minority shareholders will be an oppressive act against which winding up orders may be issued by the tribunal. where a director of a private company was removed only on the ground that he refused to consent to a transaction, the court held that to be an abuse of power which made it just and equitable to wind up the company. Ultra-vires application of funds and the consequent disassociation of 93% shareholders with the company and the persistent refusal by a managing director to hold meetings or to pay dividends have been held to be a sufficient ground to give an order of winding up. Fifthly, where the company has been conceived or brought into existence fraudulently for some illegal purpose, it is just and equitable to order its winding up. In Universal Mutual Aid and Poor Houses Association versus A.D. Thappanaidu, the main object of the company was the conduct of a lottery. Therefore, the mere fact that some of its objects were philanthropic was not a sufficient ground to prevent the company from being wound up, as it was mainly for an illegal purpose. In Re T.E. Brinsmead and Sons, the prospectus of a company stated that it had agreed to purchase the business of an existing firm, and thus the subscribers of the company's shares were intentionally misled to believe that the firm was really a reputed concern. The company was ordered to be wound up since it was formed for a fraudulent purpose. Lastly, where it is proved that an incorporated private company is in substance a quasi-partnership, it may be ordered to be wound up when there is abuse of power or breach of good faith, which the partners owe to each other. In Bhaskar Stoneware Pipes Private Limited versus R.N. Bhaskar, the Delhi High Court pointed out that the crux of the matter is not whether a member has been expelled or not, but whether there has been a breach of mutual faith and understanding between the parties. Therefore, the court ordered the winding up of the company under the Just and Equitable Clause. The relief under the Just and Equitable Clause, that is Section 271, Clause F of the Companies Act 2013, is in the nature of last resort when other remedies are not efficaciously available to protect the general interests of the creditors and the shareholders. Therefore, the tribunal will refuse to make an order of winding up if, in its opinion, some other remedy is available to the petitioners and they are unreasonably insisting on winding up instead of pursuing the other remedy. For example, in case of oppression, misconduct or mismanagement, an alternative remedy is available under Section 241. A petition under Section 271, Clause F for winding up shall not be normally entertained. Winding up order under Just and Equitable Clause may not be made in the following cases. First, where the company was at a loss but there are chances of its making profits and the majority of the shareholders are against the winding up. Second, where the directors, in exercise of their powers to do so, refuse to register the executors of the deceased shareholders even when this caused hardship to the shareholders. Third, where the business of the company was temporarily suspended owing to trade depression and was intended to be resumed when the conditions improved. Fourth, if the just and equitable ground did not exist at the time of hearing the petition, though it might have existed at the time of presenting the petition. Next, we shall discuss that who may file the petition for winding up of the company. Section 272, Clause 2 of the Companies Act 2013, which corresponds to Section 439 of the 1956 Act, provides that a petition for winding up of the company may be presented to the tribunal by any of the following. Firstly, the company. Secondly, any creditor or creditors, including any contingent or prospective creditor or creditors. Thirdly, any contributory or contributories. Fourthly, all or any of the above parties, whether together or separately. Fifthly, the registrar of companies. Sixthly, in a case filed under Section 224, that is application for winding up following an investigation by any person authorized by the central government in that behalf, or where a company is already under voluntary liquidation or under winding up by the tribunal and such voluntary winding up cannot be continued with due regard to the interest of the creditors or contributories or both, the petition for an order of its winding up may be presented by any of the persons mentioned above or by an official liquidator as provided in section 272 of the Companies Act 2013. Now we shall discuss each of the grounds elaborately. The first is petition by the company, that is section 271 clause 1 subclause A. The company is entitled to petition when it has passed a special resolution requesting that it be wound up by the National Company Law Tribunal. The company's petition has to be accompanied by the statement of affairs in such form and manner as may be. The second category is creditor's petition. Section 272 clause 1 subclause B. A creditor, secured or otherwise, debenture holder and a trustee for debenture holders can also apply for winding up of the company. Where a petition is brought by a contingent or a prospective creditor, the tribunal may admit it if there is prima facie case and the security for costs is given. The third category is contributories petition provided in section 272 clause 1 subclause C. On the winding up of a company, its members are called contributories. Where the petition is filed because of the reduction in membership, any contributory can apply. When the application is founded on any other ground, it will be requisite that the shares in respect of which the petitioner is a contributory were originally allotted to him or he has been the registered holder for at least 6 months during the 18 months immediately before the commencement of winding up, or the shares have devolved on him through the death of a former holder. A contributory is entitled to present a petition even if he is the holder of fully paid shares or that the company may have no assets at all or may have no surplus assets left after satisfaction of its liabilities. The Supreme Court in Severn Trent Water Purification Incorporated versus Chloro Controls India Private Limited and another held that the person filing the petition for winding up of a company under section 439 clause 4 subclause B, which corresponds to section 272 clause 1 subclause D of the 2013 Act, must be registered as a shareholder of the company. In other words, any former shareholder of the company whose name is struck off from the registrar of shareholders cannot bring a petition against the company for its winding up as he is not a contributory. The court further made it clear that section 439 clause 4 subclause B, now section 272 clause 1 subclause D, would not apply to natural persons who are holding shares in their individual capacities and not to juristic entities. This becomes evident from the word death mentioned in the statute, which refers only to natural persons. This was all with regard to winding up by the National Company Law Tribunal. Now we shall discuss another category of winding up, that is voluntary winding up. Under the Companies Act 1956, voluntary winding up was of two types: voluntary winding up by the creditors and voluntary winding up by the members. This distinction has now been abolished. A new beginning was made on 30th March 2017 when the central government notified Section 59 of the Insolvency and Bankruptcy Code 2016, which deals with voluntary liquidation of corporate entities with effect from 1st April 2017. Prior to the aforesaid notifications, voluntary liquidation was governed by the provisions of the Companies Act 1956. This was because the relevant section of the Companies Act were not in force. In April 2017, the Insolvency and Bankruptcy Code provided that voluntary winding up would be governed by the Insolvency and Bankruptcy Code. Voluntary winding up proceedings are now to be instituted under the Insolvency and Bankruptcy Code 2016. On a combined reading of Section 59 of the Insolvency and Bankruptcy Code 2016, Sections 434, Clause 1, Subclause C, and Section 465 of the 2013 Act and the Rule 4 of the Transfer Rules, all fresh proceedings for voluntary winding up on and from 1st April 2017 shall be instituted before the National Company Law Tribunal and shall be governed as per the provisions of the IBC Code and the regulations provided thereunder. Now let us have a look at the procedure which is provided in Section 59 of the IBC Code. Any corporate entity may initiate a voluntary liquidation proceeding if it satisfies all the following conditions. Number 1, it has not committed any default. Number 2, if the majority of the directors or designated partners of the corporate person make a declaration verified by an affidavit to the effect that A. The corporate person has no debt or it will be able to pay its debts in full out of the sale proceeds of its assets under the proposed liquidation. B. Liquidation is not initiated to defraud any person. Such declaration is to be accompanied by the audited financial statements and valuation report of the corporate person. Within 4 weeks of such declaration, a special resolution, an ordinary resolution would suffice in cases of voluntary liquidation by reason of expiry of its duration or occurrence of any dissolution event, is passed by the contributories, requiring the corporate person to be liquidated and appointing an insolvency professional as a liquidator. The creditors representing 2/3 in value of the total debt owed by the corporate person approve the contributories resolution within 7 days of its passage. This is known as creditors' approval. As per Section 59, Clause 4, the company shall notify the Registrar of Companies and the Board about the resolution passed under Section 59, Clause 3 to liquidate the company within 7 days of passing such resolution or subsequent approval by the creditors as the case may be. The corporate person shall cease to carry on its business except as far as required for the beneficial winding up of its business. Now let us have a look at the main functions of the liquidator: to value, sell, recover and realize all assets and monies due to such corporate person in a time-bound manner. Second, opening a bank account for the purpose of receiving all monies due to the corporate person. Third, distribution of the proceeds to the stakeholders within a period of 6 months of receipt of the proceeds, and to preserve a physical or an electronic copy of the reports, register and books of account for at least 8 years after the dissolution of the corporate person, either with himself or with an information utility. With this, we come to the end of today's lecture on winding up of companies. Hope you will be benefited from this talk. We shall meet again with a new lecture. Until then, take care of yourself. Goodbye and stay blessed.